appeals John Wilson against the Royal Bank of Scotland and Francis Wilson against the Royal Bank of Scotland.
Yes, Mr. Summers.
My Lords, I appear in this matter on behalf of the appellants, along with my learned friend Mr Robertson here, my learned friend Mr McElvride and Mr Sheridan appear on behalf of the Royal Bank.
Yes.
My Lord, this is, it would be wrong to say a slightly unusual case, a slightly unusual cases, because there actually are two cases. They've never been formally conjoined, but...
Could you keep your voice up a little bit?
Yes, I beg the Lord's pardon.
I'm not sure that the microphones are picking you up. I just have a little bit to do.
I'm obliged, my Lord. These are two cases raising identical issues. As it happens, two brothers living next door to one another, so they're two cases closely connected for a variety of reasons.
We can really take the facts on one case, really, for the purposes of the argument.
Yes, indeed. The disposal of one is the disposal of the other. Now, my formal motion, my Lord, is that my Lords ought to grant these appeals and restore the Sheriff's interlocutors. I have three propositions that I want to state at the outset, and then my more detailed submissions will attempt to give content and ground to those general propositions. The first proposition is this, that summary ejection by a heritable creditor of a proprietor with valid and subsisting title is not possible apart from Section 5 of the Heritable Securities Scotland Act 1894. Which provides that the creditor must make formal requisition of the principal sum and if the proprietor defaults on that requisition, the proprietor is deemed an occupant without title and as a consequence is amenable to ejection. Full stop there, and then the last is the concluding, if no requisition is made, the proprietor cannot be ejected.
You'll no doubt show us Section 5 later on, but what you're doing is simply reciting the wording of Section 5.
I am conscious that that proposition largely echoes the wording of the section,
yes.
But I thought it better to just make it clear that it is the wording of the section in great measure that we are founding on. Proposition 2.
It's really, you've got to say summary ejection of, it's not of the title, it's not of the title, is it? It's of the person.
Yes, that was what I intended to.
It's a person with, a proprietor with a valid and subsisting title.
Yes, that's the point, precisely, yeah. I mean, I will seek to demonstrate that there are remedies via different routes, but in this case, Section 5 is the way forward. It's basically what I'm saying. Proposition 2 is this, that although the word formal,
which you find in Section 5.
Indeed. In the expression formal requisition is not defined in the 1894 Act. What it infers is an obligation on the creditor inter alia to provide full details of the security. So that the basis of the demand is made clear.
Now, does that proposition extend to the position where you have two proprietors within diviso title? So does it embrace the point that that amount of provision of details must be given to both of them?
Yeah, this proposition is, in a sense, the widest of them all, because while the first proposition focuses on the fact that no requisition was sent to the wives, and it doesn't make any attempt to address the fact that the husbands were sent a demand letter. This proposition looks at the demand letter that was sent to the husbands and says it doesn't satisfy the phrase formal requisition and what the minimum content of that phrase.
Yes.
So, as I was saying, so that the basis of the demand is made clear, having regard to A, the context in which those words appear,
that is in section 5.
Indeed, yeah. Which is a proviso whose purpose is to give warning to the proprietor that his property may be expropriated.
Yes.
And B, that such information is required in a formal requisition under the Titles to Land Consolidation Scotland Act. Of 1868.
Of 1868 as opposed to 1894.
This is a different. The Titles to Land Consolidation Scotland Act is a statute that predates the Heritable Security Scotland Act.
Yes.
Which Act governed bonds and dispositions in security?
This is a very long sentence. We've had 6 subordinate clauses so far.
Would it be possible at some point to have all this on a piece of paper?
I could certainly, I've actually got it on a piece of paper here, I could certainly provide a copy of it. I did endeavour to compress it into as succinct a statement as possible, but if it makes matters easier, I'll certainly endeavour to provide a copy to your lordships.
Well, I think you should do, Mr. Summers, and there are some expressions here that may not be entirely familiar to everybody.
That's true.
I am conscious that this, in my preparation for this case, that a large chunk of the argument is to do with the Scottish feudal system and how it works. And I am conscious that that may not be...
I thought it had been abolished.
Well, it has been, but it wasn't abolished at the time that this case entered the courts, which is a long time ago.
Are we still in pre-feudal days? Are we in feudal days?
Yes, and when the action was raised.
Yeah, the demand letters were 1995, the court action was raised in 1998.
Well, I admit and aver ignorance of the Scottish feudal system.
Well, my lord, that's a very happy state in which to find oneself. But I'm going to endeavour to take it in bite-sized chunks. I don't think we're going to... The only circumstance in which an intimate knowledge of our glorious feudal system is necessary is one reads the older cases. As one reads them, if one does not know how the system operated, it can all appear a little bit daunting. But I've mercifully have Mr. Robertson with me, who spent a long part of his career before coming to the bar looking at these things. So I hope that if there are unsolicited questions from the bench as to the meaning of word sets and the like, that Mr. Robertson will nudge me and tell me what the answer is.
It doesn't look as though he's a very willing respondent.
No, I'm volunteering him for a job that he'd rather not have, I'm sure.
Well, could we be quite clear, have we reached the end of proposition 2?
We're tracked.
Yes,
We're tracked.
indeed.
Yeah.
Which Act governed what?
Which Act governed bonds and dispositions in security, which was the type of security
Sorry, wait a minute, bonds and dispositions.
in security, which was the type of security in use at the time of the 1894 Act.
Which has been removed by the standard security in the 1970 Act.
It did indeed, that's correct, yeah. The 1970 Act, the standard security, got rid of those old bonds and dispositions in security.
Right.
But
I'm very sorry, you lost me. Could you say slowly what comes in the sentence after which Act governed?
which Act governed bonds and dispositions in security, the type of security in use at the enactment of the 1894 Act.
Yes.
And that happily brings that proposition to an end. And my third is, I think, shorter, which I'm sure is a relief. Proposition 3, the common law requires a demand to be clear.
Requires the land.
Demand.
Requires a demand
Oh,
to
demand.
be clear.
I'm sorry. Yeah.
And what is required to achieve that clarity will depend on the circumstances of the case. There's a full stop there. In this case, given that the husbands could be liable under the partnership letters, the absence of any reference to the security gave the misleading impression that this was a demand of the husbands alone. And was referable to their obligations as partners for partnership debt. Full stop.
Is it referable to the personal obligation of the husband?
Yeah, it was referable to their obligations as partners for partnership debt.
If we can just return to my Lord's question on proposition 2.
Yeah.
It is presumably part of your case that the formal requisition has to be made of each
Yes, my lady.
heritable, each occupant anyway, who has a title to be there.
Indeed.
Yes.
Exactly.
Do you mean that it has to be done separately, or would a letter addressed to both of them do?
Well, I think it could be done in one letter.
Yeah.
One of the curiosities of this case is that if the secretary in the bank had taken another 5 seconds and added the words and Mrs. Wilson, a great part of my argument would simply disappear, because it would be being made clear that the demand was directed not simply at the husband but also at the wife.
Hmm. No, Mr. Summers, these propositions, I imagine, are intended to introduce the scope of your argument.
Yeah.
But what I haven't picked up so far is any reference to the 1970 Act.
Yeah,
and in particular to Section 24,
yeah, no, that will be
which is absolutely crucial to the argument, and the relationship between the two standard conditions, 91A and 91B, and the extent to which requirements for a 91A route are required to be met if you choose to go under 91B.
Yeah. Well, the next part of my submission was to give a 15-20 minute introduction to the way Section 24 fits into the scheme of the 1970 Act. But my propositions are designed to focus the points on which I think the appellants ought to prevail, which is 1, no formal requisition was made of the wives, they are both proprietors, the case fails. 2, a formal requisition is something more than the demand letters offer, because what I hope to show is that the formality of a requisition is, among other things, an indication that the person making the demand must specify the basis upon which his demand is made, so as to give indication to the proprietor that their property is at threat. And the third argument is simply the clarity point, which is, well, there was another document upon which these gentlemen could be made liable, because they were liable under the Partnership Act, they were liable under the partnership letters, which were effectively guarantees, and we will see in the fullness of time that they gave evidence that that was what they thought the bank was threatening to do, which is to sue them for money. And they didn't grasp and they didn't know that their obligations in security were lay behind that, or could be relied upon. Whether that matters one whit or not will be, of course, a matter for your lordships to determine.
Well, at some point, and maybe fairly early on, you should introduce us to the legislation.
I'm going to do that just in one moment. Right. Now, I should say that there was another argument which appears in my statement of case, which was to do with the wives as cationers and whether there should be, by virtue of that, a demand. Mr. Robertson and I have decided late last night that this is not an argument that's going to fly. Right. So we'll keep it firmly where it belongs, I think, on the ground.
Well, I was going to refer you to a case of AIB bank, or whatever bank, which was in the House of Lords, which analysed these obligations, and it didn't support your occasion, so I think that was a good decision late at night.
Well, at least I've made one correct call, so at least that is encouraging to me.
Yeah, good call.
But no, at 10:30 last night, after looking at it from every conceivable angle, we decided that there was only one possible result of that argument.
No, but I mean, you were relying on some dicta of the Lord Justice Clerk there, was that right?
Yes, I was going to take my lords to Smith and the Bank of Scotland and what Lord Gill said about the obligation.
You're not supporting.
But I'm not running that argument, no. It would appear to us that if you're simply confining the argument to the wording of the bond, that it would have been open to the bank to say, we demanded of you, the husband, you, the wife, offered your property and security of that, you're liable. If one's confining the argument simply to the wording of the bond, I trust my lord is with me on that simple proposition, and it doesn't seem to me to be one that I should waste your lordship's time with.
Yeah. Very well.
So, introductory matters, the 1970 Act. I want to take my lord on a
yes.
I'll look at that. Now, there are two things I want to say about the 1970 Act before we look at its detail. The first is this, that it is not a comprehensive code. I think that is critical to the appellant's case.
That means to say that you have to look to Section 5 of the 1894 Act to understand your argument. Yeah, that's it. Yeah.
And not only in connection with Section 5, I think my Lord and the Chair pointed out in another case that the 1970 Act was never intended to be a freestanding, free-floating code of rules for standard securities. And one has to see that some parts of the underlying law were repealed and some parts were retained. Yeah. So it sits alongside and fits into the pre-existing body of law. Yeah. And that is it's a critical submission for me, that, because it shows that Section 5 of the 1894 Act was deliberately retained, as I hope to demonstrate in a moment. Yeah. It was there because if a heritable creditor wanted to enter into possession by means of ejection, in the circumstances of this case, Section 5 required to be paid in aid. So it's not a comprehensive code. And the second main point is this, and I'll take
Can I just say, to the point you just made is really made very clear by Section 32 of the 1970 Act, isn't it, which you'll show us in a moment, which does refer back to previous provisions. Yes.
just in 1 second, I'm going to take my lord right through the 1970 Act and show that in a whole variety of connections that there can be no denying that the 1970 Act was meant to slot into pre-existing law and not stand free from it. So it's not a comprehensive code. And the second general point is that Section 24 is one of 3 possible methods of realising a security. Now, tab 2 is where we find, in the authorities volume, is where we find the 1970 Act.
And we're looking at the Act as originally enacted, are we, in this case?
Yes,
I mean, there have been some changes, but we,
it's
we don't need to
been
look at them.
substantially amended, but at the time this action was raised, and at the time the events, the issues, the demand letter and so on and so forth was complained of, that the 1970 Act was in force as unamended.
Are we supposed to have the whole Act? Because I didn't seem to have pages 1 to 6.
No, I've decided that it's not necessary or desirable for the whole Act to be photocopied. I have just photocopied selected parts. You should, my lord, have more than that.
I thought I had the whole lot.
I think I do too, but we don't need to worry with part 1, which is dealing with...
Not part 1, sorry.
Yeah,
No.
what I've done...
Part 2, the whole of part 2.
Whole of part 2's there, yeah, and that's the bit that governs standard
Yes.
securities.
Yes,
Well,
part
I'd
1
like
was
to have
dealing
that.
with a different thing, which
Yeah.
was land obligations and so on. So we need the whole of part 2.
The whole of part 2, and I've also, the other critical part are the schedules, which again are photocopied and
Yes.
included. So the first is page 16 of the Act. And it's section 20 that I want to direct attention to, section 20, subsection 1. And this is in that section of the Act where the calling up notice is under discussion. Calling up notice is introduced to us in section 19.
Well, just to be quite clear, I wonder if I can just try to put this into context. One ought really to begin at the standard conditions, because the standard condition 9 has 2 alternative routes, 91A and 91B.
Yeah.
And section 20 is dealing with the 91A route, whereas in this case, the bank, for some reason, has decided to choose to follow 91B, which takes you to section 24. But if I think I understand your argument, you're going to say that we have some guidance as to what is required if you take the 91B route from what you have to do if you follow the 91A route. Would that be right?
That's correct, my lord, yeah. I've got a narrower issue before me at the minute, which is to demonstrate to my lords how the Act explicitly acknowledges at various junctures that the remedies it affords are without prejudice to the remedies afforded by underlying statute law and common law. That's the narrow point I'm trying to demonstrate. I think it's a very important point, my lord, because I do want to take a moment just to show how the Act doesn't attempt to override, except in as far as it expressly repeals the underlying means and methods of realising standard securities. So that's the narrow purpose for which I'm taking my lord to section 20 and other parts of the Act, as I will do just in a moment. If I can just read section 20, is where the debtor in a standard security is in default within the meaning of standard condition 91A, the creditor may exercise such of his rights under the security as he may consider appropriate. And any such right shall be in addition to, and not in derogation from, any other remedy arising from the contract to which the security relates, or from any right conferred by any enactment, or by any rule of law on the creditor in a heritable security.
Now, this assumes that a calling up notice has been served, does it?
Yes, that's right.
And calling up notice under section 19, is that required to be served on each of the proprietors if there are more than one.
An important point, again, if one just stands back, if I may, just from the flow of argument, and say that it would be really strange if a formal requisition only ever required to be served in one proprietor and not the other, when if one looks at the calling up notice, indubitably it has to be served in both. And calling up notice is just a species of formal requisition. But I come to that argument. The narrow point, or the important point I'm trying to emphasise at this stage, acknowledging this is not a calling up notice case, except I understand that. But if we look at this route of realising your security, what we find is that the Act is making it very clear that the fact you've got this right, it's not in derogation from existing remedies under contract, if you provide yourself with that, or the common law, or statute law. So the important point to grasp is that the Act is telling us that it's not a self-contained code, but it fits in to the substratum of underlying law.
Well, it's intended to give the bank or the lender further rights, isn't it?
It is, my lord.
I mean, they were getting rid of all the existing forms of security over land. And what they were doing was bringing in this new, supposedly simple or simpler beast called the standard security. But then what they were doing, I think you're saying, is they said, okay, all the law, or subject to anything in the Act, all the law which used to apply, all the common law which had been built up in relation to existing securities under the ones, you apply them to this one. Is that right?
Yep.
In where it's indicated, for example, here in 20 subsection 1.
That's right. Yeah.
Was this Act the result of recommendations by the Scottish Law Commission?
The Halliday Committee certainly sat at length, and I'm not sure whether the Scottish Law Commission in existence.
Professor Halliday was on the Scottish Law Commission.
He was, yes, that's right.
So I think it would have gone through.
Yeah, there was a very extensive and a very lengthy report, but I have read it, and there's nothing that sheds light peculiarly on this problem in the report. But it certainly, sadly, there wasn't such a thing with the 1894 Act. I searched to try and find whether there was any background discussion of why the 1894 Act was brought in and what it was intended to do, but I found nothing in Hansard or anything of that sort.
I mean, it rather follows, as far as I can see, these things which one looks at, the Scottish conveyancing things, you find notes and so on, and this is very much that, notes to Schedule 4 and all that sort of stuff. It's that kind of, it's a conveyancer's statute rather than a statute which ordinary mortals would ever have dreamt up.
Well, I will be taking law to section 119, I think it is, of the Titles to Land Consolidation Act, which runs nearly 4 pages. And when you begin to look at it, you think, is this the longest section on the statute book? But when you look at it, actually what it is notes of guidance. After you've gathered up the courage to actually concentrate and say, what is this section saying to me? Well, actually what it is guidance notes. So there we go. It is a peculiar area of the law. Now, section 21 contains another example of the same proposition. If my lords don't require me to labour this point, please tell me, but I think it is an important point just to lay the foundations. 21.1, this is a notice of default, which is the second option provided by the 1970 Act. Where the debtor in the standard security is in default within the meaning of standard security 9.1b, and the default is remediable, the creditor may, without prejudice to any others he may have by virtue of this Act or otherwise. So it's clearly acknowledging that the Act is not self-contained and that one looks elsewhere if one is seeking for remedies.
It is interesting to look at Schedule 8, which is to be read with Section 32, because it does give us just a snapshot to see to what extent the earlier statutes, which are quite a number, still remain in play. If you look at Schedule 8, which is at page 46 of the print, you can see that bits are taken out of the various statutes. But if you look at the 1894 Act, and you were mentioning Section 5, that isn't excluded.
Although that was my peroration.
This is an example, really, of how it's been very carefully crafted, that bits of it which are relating to the old form of security are taken out, but bits that can apply to the new form of security remain in.
Yeah, well, that was going to be my very final point, and I thought, in my respect, the most telling point of them all, which is when one does get to Schedule 8, you find a section there in paragraphs 18 to 24, the Heritable Security of Scotland Act of 1894 is explicitly addressed, and Section 5 is not repealed.
No, and these are excluded enactments rather than appealed, because in 1970 there would have been thousands of securities which had to continue in existence, and probably many of them still do exist. And so they couldn't repeal the acts, but they just excluded them from application in relation to the standard security.
That's right. From that point on, the only way of creating a security was to do a standard security. I have other examples, but I think the point is, I think, pretty clear that Section 5 is part of the scheme, because the 1970 Act acknowledges it, and it fits into the way the 1970 Act works.
And are you saying it limits the bank's rights and as a result of serving up either a calling up notice or a default notice?
Well, what I'm saying is that if a bank wants to enter into possession of subjects where the owners of a heritable title are in possession, physical possession, whether you proceed by Section 24 or whether you proceed by the calling up notice procedure, which is another form of formal requisition, the only way of ejecting proprietors with a title is through Section 5.
Is it helpful to look at Section 25, Mr. Summers? It's in tab 5, but it is really helpful.
Let us just look at tab 5.
Because what I would find helpful is if you could see how the wording of that fits into the position of the bank in this case. Whether there are words there that actually describe what the bank is seeking to do.
I'd be happy to take my lord through the words used here and explain how I understand them. Section 5 is found at tab 5, and what it states is where a creditor desires to enter into possession of the lands disposed in security. Now, if we just stop there, I'm going to take my lord to Professor Gordon's textbook and show that possession is a distinctive concept of Scots law, and may be either natural or civil. And then secondly, and this is perhaps crucial, and the proprietor thereof is in personal occupation. So the ambit of Section 5 is cut down by that. It would have no reference at all to a circumstance where a proprietor had title but was not in personal occupation. This is perhaps why this section is so important to the domestic security, is that typically you will have people who are in actual occupation. So the proprietor thereof is in personal occupation of the same or any part thereof. And the third main, such proprietor shall be deemed to be an occupant without a title. Now, my Lord Roger will immediately hear echoes of Roman law in that, and how squatters, people whose titles are out vi, out clam, out precario, who are possessors without title. They have no right to be there. And they are the people that are amenable to ejection. There's a quite separate remedy in Scots law if you have title, and that is an action of removing. So what this section does, such proprietor shall be deemed to be an occupant without a title, and the creditor may take proceedings to eject him. Now, ejection is the remedy for a squatter, or for the person who has no right to be in the land, in the same way as if he were such occupant. And then here is the proviso: provided that this section shall not apply in any case unless such proprietor has, 1, made default in the punctual payment of the interest due under the security. Now, that addresses the situation where there's a contract in place, there are monthly or termly payments of interest, and the debtor has failed to make payment of interest at the term. That is a breach of contract. That would be a breach of contract and entitle the bank to their remedies. Or, in due payment of the principal after formal requisition, and that addresses a separate situation, which is not failure to pay interest due, but where there is a principal sum due to be paid. And that's the circumstance in which we are in this case, when one recollects that the debts were partnership debts. They were accumulated by the two firms, Wilson Brothers and F.G. Wilson Associates. And the liability of the husbands was partners for those debts under the Partnership Act, as guarantors under the partnership letters. But the wives, critically, had no hand in the creation of those debts. They were not partners. They were not signatories to the partnership letter. Their liability, the only way the wives could be made liable for their husband's debts, is through the personal obligation in the standard security. And that debt is a principal debt. That accumulated debt on the accounts of the partnership is a principal sum. And what this section is telling us is that if you want to exact payment of that sum and propose to exercise your rights in security, there must be a formal requisition.
And the word proprietor in the singular includes the plural.
Indeed. It's a peculiarity, actually, the 1970 Act, is it addresses everybody in the singular, the debtor, the proprietor. You see it here as well.
Does this only apply in cases where the debt is, the obligation is in this standard security?
Well, it applies in two circumstances. It applies where there's interest due.
Under the security?
Yeah.
Yes. Or in due payment to the principal?
Yeah. Well, the way the narrow way of reading it might be that you've got a principal sum lent under the security and the interest running thereon.
I mean, in this case, the obligation is, as I understand, part and parcel of the standard security, isn't it? Because the two, it was included in the one document, isn't that right?
It's in the one document. As my lord will be aware, they are distinct. They can be severed from one another.
That's what I was getting at.
Yeah. For example, the bank could, if they had chosen, could have sued the obligants in an action of payment. You know, the bond, the preamble, the personal obligation contains a personal obligation. Yeah. We undertake to repay on the
Can we just look at the document?
Yes, by all means. Yeah. It's in the core volume. And
page 189, is it?
Well, there are two securities. 189 is the Francis Wilson, and
I see. Yes.
There's an absolute, a complete replica of the document with minor differences at page 206.
Right.
But 189 will do, will it?
Yeah, we'll do with 189. Yeah.
So the structure of it is what we have: the personal obligations at the beginning.
Yeah. And then the part that offers security is in the following page. My Lord will see the second paragraph. If one just removes the bracketed section there, for which sums the the said Francis John Wilson and Mrs Annette Wilson.
Sorry, where are you now?
This is page 190 of
Yeah.
the bundle, page 2 of the security. For which sums the said Francis John Wilson and Mrs Annette Wilson. I'm excluding the little section there to do with the Consumer Credit Act. Does my Lord see that there's a...
Yes, yes.
I'm just ignoring that because it doesn't make any difference. For which sums the said Francis John Wilson and Mrs Annette Wilson, presently residing at,
Well, they should have deleted that
Yes.
bit, shouldn't they?
yeah, well, these are not a sub-secretary somewhere in a bank in Loan Head, I think.
Yeah.
But we're not concerned with these infelicities in this case. For which sums the said, Mr and Mrs Wilson hereby grant a standard security in favour of the bank over all and whole.
I mean,
So what my Lord Roger is asking about, just stepping away from the kind of the logical progression of my argument and just to explain how I understand this works, is that under the 1970 Act, my Lord, it's possible to have two documents. I think it's called a Form B security, where you have the personal obligation in one and the security in a separate document. In this case, the two are, but that doesn't mean they're not severable. You could sue under the personal obligation and never bother to call up the security. I mean, for example, if it were to be the case that the Wilsons were wealthy and there was a large bank account somewhere or other that they could access, they could just sue under the personal obligation.
I mean, I was just puzzled by the phrase due under, what is it, under the security? I mean,
We should perhaps look at the opening words on 189 and paragraph 2 on 189, shouldn't we?
Yes, my Lord. This is what we call the personal obligation, sometimes called the bond. And what they state is, we, Francis John Wilson and Mrs Annette Wilson, residing at 63 Park Avenue, Loanhead, Midlothian, hereinafter referred to as the obligant, hereby undertake to pay to the Royal Bank of Scotland, hereinafter referred to as the bank, which expression includes its successors and assignees whomsoever, on demand, all sums of principal, interest and charges which are now and which may at any time hereafter become due to the bank by the obligant, whether solely or jointly with any other person, corporation, firm or other body, and whether as principal or surety. Now, the other little bit of the security that you need to know about to understand that is the second paragraph, numbered paragraph 2, just a little further down, where the obligant is defined to mean either or both of them. You actually can't understand the bond without appreciating that. And this is why my fourth argument came to grief last night, because when you read this, you might think, well, it's a demand of both of them. It's got to be addressed to both of them. That seems, but then you look at obligant, you discover that's not the way it's intended to be understood at all.
I thought your case was, the part of your case was that this may create a personal obligation on both husband and wife, but that's a different issue from what demands or notices have to be given.
Yes, my Lord. Yes, if I didn't intend to.
Right.
To suggest otherwise. My point is that if you want to exercise your rights and security, you've got to rely on Section 5.
so can we just be quite clear, what is the wife's obligation here? Or the wife's obligation?
Under the bond, she has an obligation to pay. And she has an obligation, should the bank seek to...
She has an obligation to pay what?
pay all sums on demand.
How does that obligation arise?
On demand.
Yeah.
It's got to be due to the bank
Yeah.
by one or other or both of them.
Yeah.
And then, as an obligant, she's promising to pay on demand. That's how it works.
That's exactly how it works. Yeah.
Yeah.
So,
But the demand has to be made of each obligant before they can be liable.
That's the question.
yeah, well
In terms of personal liability,
precisely,
the cause of action against Mrs. W
yeah.
only arises, the bank has to prove two things. One, what the underlying liabilities are, and two, the demand
Yeah.
of Mrs. W.
what we're doing is we're looking at the contractual arrangement, and what my lords must do is appreciate that when one is asking the separate and distinct question is what remedy are they entitled, the bank entitled to exercise? Can they eject, which is what this action is about. It's a summary, it's an application, it's a crave for summary ejection. They've got to go to Section 5 to get that remedy.
So
Yes.
we go back one stage. The Mrs. Whatever she is, Mrs. Wilson, has undertaken to pay, among other things, to pay the debt, the debt which her husband has incurred in the partnership. Yeah.
Yes.
Now, he is a letter is sent by the bank to him.
Yeah.
And that you accept is good enough as far as, let's assume, is good enough as far as he is concerned,
Yeah.
to indicate that's a demand for him to pay them, to pay. Now, is that enough to require her to pay? Is that a demand on her to pay?
If this action was an action of payment,
Sorry?
if an action had been raised for payment, it would be.
What?
Why?
Why? She's liable for sums due from him,
Yes.
but she's only liable to pay on demand.
Yeah.
Why is asking him for them enough to ask her for them? I don't understand that. Husband and wife are separate people in Scotland as well as in England, aren't they?
Yeah. Well, if my lord gives me one moment, perhaps.
I mean, it's a red herring whether they're husband and wives, actually. It would be
It
true
is.
of any two,
Yes, yes.
two
Yes.
These could be strangers to one another,
Yeah.
complete strangers.
Yes. But if you look back at page 13 in the bundle,
Yeah.
that's where we see the partnership letter.
Yeah.
And the wife is not a party to that letter.
Exactly.
But as you've pointed out, she comes in under paragraph 2 of the personal obligation
Yes.
in the standard security. But at the moment, I don't quite see how that matters when we're concerned with the calling up of the security itself, the enforcement of the security.
Yeah.
Because we're not, the bank is at this stage not enforcing the personal obligation so much as the
That is right,
security
Lord.
obligation.
And that is why this is possibly another red herring, is that it's not just that the fact that husband and wife's a red herring, but it's actually, all I'm endeavouring to do is to try to give my understanding of the broader picture as to what the personal obligation imports. But what my big point is that if they want to exercise the remedy of ejection, Section 5 makes it crystal clear that a formal requisition must be made of the proprietors, and she is a proprietor, and no formal requisition.
Are there any provisions in the schedule about possession, taking possession of the security?
In the schedule
I
to
see that on
1970
page
Act.
191, there seems to be some kind of amendment of the schedule.
Yeah.
Are there any, what other provisions are there in the schedule to the 1970 Act about a lender taking possession of the secured premises?
Well, there's not.
Is there anything?
There are undoubtedly one of the standard remedies that Schedule 3 gives, and Condition 9 is the right to enter into possession.
Could we just look at that?
But Schedule 3 contains the standard conditions.
It does. If one looks at, it's page 38 of the statute, and at the foot, Condition 10. Do we not have that? Page 38, Condition 10 is down at the foot, and we see the little marginal annotation, rights of creditor on default. And just to read it, where the debtor is in default, the creditor may, without prejudice to his exercising any other remedy arising from the contract to which the security relates, exercise in accordance with the provisions of Part 2 of this Act, and of any other enactment applying to standard security. Here's another example of the acknowledgement of underlying law, such as the remedies specified in the following sub-paragraphs as you may consider appropriate. Now you get sell, which is the first, then my Lord Clerk, it's the next one, enter into possession, for when he has entered into possession, 5 when he has entered into possession, and so on. The remarkable feature, of course, of this is that it tells you about entering into possession, but it doesn't say a word about the remedies that get you that right.
So you need to look at Section 5 of the 1894 Act
Exactly.
in order to see what happens if, reading the formula in Section 5, you find that the proprietor is actually in personal obligation, personal occupation.
Yep.
So it's fine if, as I think you said earlier, the proprietor is not in occupation. You can then enter into possession because possession is available to you. But if the proprietor is there,
Precisely.
then, although it doesn't say so in paragraph 10, you've got the remedy that Section 5 provides, plus, of course, qualified by the proviso that you drew our attention to at the beginning.
My Lord, as well, I'm not sure where I am in my submissions at the minute, but the other point that I was going to take my Lord to is that removing is the remedy afforded by the common law when you have a proprietor with title. And that remains intact.
I think we need to clarify what you mean by removing. That's a different process from summary ejection.
Yeah. The old way of describing it is an action of declarator and removing, and I'll take my Lord to the authorities that describe it. Ejection's a different animal. Ejection is the remedy when you get the squatter, somebody with no title. Removing is the remedy when you have somebody that has title. And the point of Section 5...
But what practical difference does it make? They're different courts, are they? Ejection is quicker, more summary, is it? And what real difference does it make?
It's a summary process, my Lord. That's the point of Section 5, is that it gave the creditor a summary route through to possession.
Can we just be quite clear what this means? Both of them go to the Sheriff Court, but there is a summary procedure and there's an ordinary procedure, and there are different rights of appeal, I think, depending which procedure you use.
Yeah.
And I think one of the points one of the Sheriff Principals makes in one of the cases you'll be directing us to is that it's quite important because of the rights of appeal to be sure you're under the correct process.
Well, I hadn't, my Lord, proposed to get sidetracked into the major procedural spat that was played out when the sheriffs were trying to decide whether there should be ordinary procedure or summary procedure. I don't think I require to go that direction, but what I'm driving at is that the innovation of Section 5 was it said, look, you have a man or a woman that has a title, entitled to be in possession, got a recorded title. Now, at that time, the common law said an action of declarator and removing. Now, what Section 5 did was say we're going to abridge that.
Yes.
And we're going to treat somebody with a title as a squatter.
So the
word, and being able to summary ejection.
The critical word from that point of view in Section 5 is the word eject.
Precisely.
Which indicates that you're not dealing with the removal process. You simply want them out, which you can do by a summary process.
It used to be, I don't know whether the law would countenance it now, but the older authorities countenanced the possibility of the proprietor going down to his land and physically ejecting people who were there without title. But I think the law has moved on a little bit since then. But the point of it was that it was a summary, expeditious process that you simply turned off the land, people with no title to be there. And Section 5 is effectively a deeming section, which deems somebody who has title to be somebody without title.
But it's accepted, I take it, that simply by saying in Standard Condition 10(3) that the creditor may enter into possession of the security doesn't actually tell us how he physically gets hold of the property.
That's
because he's obviously got to go to court to do that.
Where is the provision that says he has to go to court to do that?
That's the point, isn't it?
Right. I mean, section.
So where is the provision that says he has to go to court to do that?
Well, it's Section 24 in this case, which...
No, I would thought the answer to that question is Section 5, because it says the creditor may take proceedings to eject him. And really, Lady Hale's point is that on subsection 3 of Standard Condition 10, it doesn't actually say anything about the process. And
No.
the one thing that's absolutely clear is you can't just wander along with a mallet or something and turf them out. You've got to have an order from the court.
That's if it's a
Should
personal.
say shall.
But I mean, supposing it's not. Supposing the proprietor isn't in personal occupation. Can I not just go along and say, I'd like to get in now, thank you very much?
I suppose probably yes.
Well, why not?
Well,
I mean, of course, they may resist and so on, and then you may have to go to court. But I mean, why should I go to court if
if it's lying empty, yes, exactly. No, I think
Section
Or
5.
if the proprietor is a company,
Yeah, exactly.
which is the more
Yes, exactly.
actually an occupation, but a company.
Yeah, well,
Do you have to go to court in Scotland?
well, not under Section 5. I think Section 5 is directed as the wording of the section specifically says. It's personal occupation. It's,
So may should read shall, or means shall.
I'm just trying to get at the underlying position,
Yep.
because you are stressing that the underlying position was not affected by the 1970 Act. So I'm just trying to
Yes.
understand what the position in Scotland is for actually physically getting hold of premises.
Well, 10.3 tells us, isn't it? He may enter into possession of the security subject.
Yep.
But if somebody is there in personal occupation,
Yeah.
then you've got to use Section 5.
And that is where we are in this case. Is we've got
Yes.
couples and their kid. In one case, a
I
child.
suppose a tenant was in possession. Could you, do you have to go, is there a general provision in Scotland which says that you have to take court proceedings to eject somebody who's living in the property? I mean, in England, there's a general provision, as I recall, which provides for that.
Well, I think probably with a tenant, what the creditor would do was enter into possession so to take the rents. He wouldn't want to physically eject or get rid of the tenant because the right to gather the rents would be a valuable
Might or might not,
asset.
that depend upon whether the tenant was good for the money. But
Well, that is a
That's a
different
separate question, isn't
yeah.
it? But
typically,
this is your point about possession being different from occupation.
Yeah, exactly. There's the old remedy.
I want to answer my question. Is there a general provision in Scotland that says that you can't take nobody can take possession of a property where somebody else is living in it without getting an order of the court?
That general question, I think I probably have to
I think
ask
the
Miranda
answer,
Junior about.
the answer to that question, I think, is yes, because there's a statute that applies in England, and
Yes,
my
there is,
understanding is it applies to Scotland as well. I can't remember which it is, but I've always understood that the answer to the question was yes. You can't, as it were, deal with it brevi manu,
Yes.
simply by your own hand.
I had really prepared to answer that very general question as to what the position might be in its generality. I'll speak to Miranda Junior.
And your point is under Section 5 that formal requisition means not just formal requisition of the monies, but formal requisition, if you like, of the property. Is it? If you is it sufficient to make a demand of the money? Let's say the same demand as is in any event required in order to, under section page 189.
My understanding
Would a notice which satisfies 189 be a sufficient notice under section 5?
a notice which satisfies section.
Which satisfies the demand provision in the contract at page 189. Would that also satisfy the requirement for a requisition under section 5?
Well, that is one of the questions.
Well, I'm asking you what your submission is to
the
answer.
Well, my submission is that a demand under the bond, the personal obligation, should be the same as, it contain the same detail and information as the formal requisition under section 5. So it designs the parties, identifies the security and the security subjects, demands as a peremptory demand for payment. We demand of you, you pay, in this case, a sum of principal, and either stipulate the time for payment or leave it for implication as a reasonable period of time. And that would be
sufficient.
Yeah.
You don't have to demand possession.
I don't believe so, my lord. No.
Well, so my note of the submission you made about half an hour ago was formal requisition goes beyond the demand letter. It must say your property is at risk. Is that, did I misunderstand that?
Well, I didn't intend to suggest that the words "your property is at risk."
Well, I do not those precise words, but
Yeah.
to get across not just you're asking for money,
Yeah.
that you were threatening to enforce the security,
Yeah.
which may mean you're going to lose your home.
And that, I say, is achieved by including in the demand the reference to the security and the security subject, so that the debtor is under no doubt that the demand that is being made of me is a demand under my security. Might I?
So it does have to go further than the demand, which would be sufficient to satisfy the contractual, the contractual requirement for a demand.
No, well, my submission is that a clear demand, if a demand at common law requires to be clear, I say that that clarity is achieved by telling the debtor that it is being made under his standard security. I am being driven off course rather at the minute, and I would, if I may, try to return to...
Well, before you return,
Yeah.
Section 5 is dealing with, am I right? It's a disposition in security, is that right?
Yes, Lord.
And that would be a bond and disposition.
Exactly.
In security, yes? And the bond would be the thing which created the debt, would it?
That's right, yes.
Including the interest.
Exactly.
So that's why is that right? That's why we find reference to payment of interest due under the security. And I would have thought probably, maybe, the principal would also be due under the... Now, does that apply happily with the... in this case, I suppose you can say in one sense, it's a bit like a bond, because you've got the principal. But we know that there are other obligations where the obligation is set up, first of all, and then somebody grants a standard security. In that case, would this apply?
Well, I have been prepared to accept that it would apply because...
Very kind of you, but would it?
my
Does it,
submission-
under the security, would it be under the security? In what sense would the interest be due under the security?
Well, in this case, we've got an all sums security, which for all sums of principal, interest and charges that are due. The all sums here...
Is that be due under the security? It's due under the obligation. Supposing, I'm just testing, here we've got it in the one document, so probably it doesn't actually arise. But supposing it weren't weren't the case.
Yeah. Well, Mr. Robertson and I have gone round. Our view is that the partnership debts here are due under the contract between the bank and the partnership.
Exactly.
But they're also due under the personal bond in the security, for it's an all-sum security. So it covers those debts.
So is that, back to page 189, we're looking at personal obligations granted at any time. It could include obligations granted before the security was entered into or afterwards. Is that what you're saying?
Yes, that's what I'm saying.
What does as far as as I understand it here, may be wrong, that the bank are, as I think you've said already, they're not saying that they're not saying the wives owe the money. They're saying the wives granted security for the debt incurred by the husband.
Yeah.
Is that right?
That's right.
Yes. Now, as far as that is concerned, the debt, as you've just explained, I think, would be under the partnership.
Yep.
Now, does this here, this thing we're looking at on page 189, does it add anything to that? Is the obligation on the part of the obligant here, and does that add anything? Is it of relevance in this, or is it of relevance to this present dispute?
Well, I see that it is because the principle, my understanding is that the principle here is a word in this section that is apt to cover the debt that is due One, by the partnership to the bank. Two, by the partners as guarantors and as partners under the partnership act. And three, because the wives have signed up to an all sums security, and they have accepted that they will pay sums due by their husbands.
So maybe it's for which sums on occasion, page 190, takes us back to the sums which are narrated on page
Yes.
189, is that
Yes,
right?
Lord. Yes.
Such sums.
What we accept is that although the wives had no hands in creating this debt, they weren't partners, they never weren't party to the contract with the bank, they weren't guarantors under the partnership letters. What we accept is that that personal obligation that they are undertaking to pay the debts of their husbands.
But as far as the husband is concerned, what he's doing is he is undertaking, is that right? To pay on demand all sums which are now due to the bank.
Yes.
Is that right? So he owes the bank under the partnership agreement, is that right?
That's right, Lord, yes.
Is that right? Is it under the partnership agreement? Where do we get the partnership agreement from? 189.
I've never said partnership agreement.
Partnership letter. I beg your pardon.
And the partnership letter comes after the security, I think, doesn't it?
Yeah, well,
Because I think the security was recorded in December 1991, and we've got these two letters coming in 1992 and 1993.
Right,
so,
yes,
194 and 210.
yeah, so this is may at any time hereafter become
so
due.
that's a hereafter one.
So it's swept up by the other words.
yeah, the partnership letters are the second and third documents in the core bundle.
Yeah.
The critical words in the partnership letters are
What page are they dealing?
Page
it's
19.
page, beg Lord, Lady
Sorry,
Parliament.
13.
It's number 13 and 14 in the core bundle in the tab called appendix.
13 and 14.
Is that the same as page
Number,
210?
please. Page number, will be a page number.
Page
13 and 14.
Page 13 and 14.
So there are two letters, different dates, of course.
If one looks at it, the primary purpose is to authorise these gentlemen to sign cheques and for the cheques to be paid by the bank. But if one looks at the first large paragraph, it says, by any of us on behalf of the firm to debit such cheques, bills, promissory notes, orders to the account or accounts of the firm with you, whether such account or accounts are in credit or overdrawn, or may become overdrawn in consequence of any such debits. And this is the point. And we will be jointly and severally liable or responsible for the repayment of any indebtedness or liability incurred by the firm and interest and charges thereon. That is just exegetical of a liability they have anyway under the Partnership Act. I think it's section 8. Just the partners are cationers for firm debt. And that's what that does. It just puts in writing what is the case anyway.
Mm-hmm. So the standard security enlarges upon what you see page 13 by saying that because the obligant includes the wife, she is jointly and severally liable along with the husband.
Yeah. My Lord has the point precisely. So if one looks at this in its pieces, first of all, the bank could have sued the firms for payment if there was any money in the firms under the terms and conditions of borrowing. Secondly, they could have held them liable under the Partnership Act as cationers for firm debt. Thirdly, they could have gone after them under these partnership letters, but that adds nothing to the Partnership Act. But what they've chosen to do here is to utilise the remedy available to them under the personal bond, and that is a compendious obligation. And one of the features of it is that it makes wives liable for their husband's debts.
And of course, that's the way into the security, which is granted by them both, and it's necessary to be able to remove both of them. because they're both in possession.
That is how I've analysed it, Lord.
But supposing the wife hadn't undertaken the liability, but nonetheless had granted the security, that'd be all right. That would be enough to sink her, wouldn't it? If the procedure was gone through properly.
If the lady had never signed the standard
Supposing she weren't a debtor, but nonetheless she had granted security for her husband's debts.
Yes.
And he didn't pay, then the bank would be able to exercise their powers against her under the security.
Yes. Just as if paragraph 2 on page 189 wasn't there, nevertheless, for these sums, the security is granted by them both.
Yeah.
And that would be, the obligation would be to pay interest due under the security within the meaning of Section 5, would it? In that,
well,
because you'd have to construe Section 5 as including that circumstance.
Otherwise
it wouldn't make any sense.
I had rather thought that the interest part of Section 5 didn't really bite here because
Well, maybe not, but then,
what I think it anticipates is that you've got a bond in disposition in security with monthly or termly payments of interest on the principal, and that there would be a date certain on which that interest would fall due. And if the debtor failed to pay the interest on that date, there would be a breach of the terms of the bond in disposition in security, so there'd be a contractual breach. But what if the principal isn't due to be? What if the bank just want their principal money back? So that what they do to make that prestable, they demand payment of the principal. And what Section 5 does, in my respectful submission, is that it covers the circumstance we're in here, which is where it's not a principal sum advanced by the bank on which interest is being calculated, but it covers the situation here, which is the principal sum is due, having been accumulated by the partnership as a debt, and for which she, because it's an all-sum security, is liable.
in order to recover the monies under the, in an action for money from the wife, you'd have to, if you wanted to recover the monies from the wife, you'd have to make a demand under page 189.
Exactly.
But if you didn't want to do that, you wouldn't have to do that, would you? It'd be sufficient to make a demand under the husband, aver the liability of the husband and the demand made to the husband, which would be necessary to complete your cause of action against the husband. But then you'd have to, then you'd want to exercise your security against both the husband and the wife, since they're both living in the property.
Yeah.
And in order to do that, you say, you'd have to comply with Section 5, including its proviso, and that would include, you say, a formal requisition of the wife as well as the husband.
Because she owns a half share of the house.
Yeah.
She's a proprietor. Yeah.
Well, it's not sufficient to give the notice of demand to the husband, because you'd have to make a formal requisition of any proprietor in possession, because that's the whole point of Section 5.
Yeah, that is precisely the submission.
Precisely.
Yeah. I was seeking to try and put Section 24 into context.
So what is it? Supposing the wife hadn't signed this, the first part, wasn't a co-obligant, but had granted the standard security.
Yes.
In that situation, how would Section 5 work?
Would work.
Yeah.
I'm not sure.
Well, the proviso is difficult to work.
It is really. Can you say she's in default when she hasn't any obligation?
Yeah. I mean, I have to. There are. The more one postulates alternatives, the more holes that you can see opening up. But happily, my task is a simpler one, which is to confine myself to Section 5 of the facts of this case, which is that, you know, she has signed the personal obligation. She is a proprietor in possession. She is, therefore...
Yes, but if there hasn't been a demand, she may not have made default in the punctual payment under the security.
The bank don't want her to pay. They want him to pay, failing which they want to exercise their standard security. That's the position. Now you say in order to do it, they've got to, but I mean they don't want her. They're not saying she should pay. The trouble about Section 5 is it looks as though it assumes that that the proprietor will always have been somebody who is who's...
Perhaps you have to give a purposive construction to Section 5, because the whole point of Section 5 is to protect proprietors in possession.
It's because Section 5 was designed for bonds and disposition and security, where the bond, the person who granted the bond also disposed the property.
Yeah.
That's how it worked.
There is another aspect to this, of course. The standard condition 9(1)(b) is worded in such a way that it can cover securities granted in security of obligations other than obligations to pay money.
Yes, no, absolute obligations
And
of fact and
at
price
the moment, I
standard.
don't quite see how Section 5 can apply there, because it's talking about interest and principal, which is money obligations. So would your position be, if we were dealing here with a different kind of obligation, which is some sort of obligation to do something or possibly not do something, then the Section 5 route would not be one that would be available. And what would then happen? I mean, how do you operate standard condition 10?
Yeah, but what I say there is that the common law remedies are still available to you, and that you raise an action of declarator and removing. You have it declared that the obligation is in the contract. You have it declared that there has been a breach of that obligation. The court then pronounces an order of removing. And as I understand it, and I'm grateful to my learned friend Mr Robertson for this, because he knows more about conveyancing than I do, but as I understand it, what the habit was to tag on to that an alternative crave for warrant to eject. Because what would happen is, if the order of removing was pronounced and the individual didn't comply, you would just either reapply to court for the warrant to eject, because there was no longer a valid subsisting title, because the court decree had evacuated that. Or alternatively, the court would pronounce an order, effectively an omnibus order for removing, and which failing, ejection. So you would get both your remedies at the one go, as it were. Does my Lord follow the point I'm making? What removing was about was, as I've indicated, was where you had somebody who has a valid title, is entitled to be there. So what you would do is, in the case of the obligation ad factum prae standum, you would aver that there was an obligation on the proprietor to perform an obligation. You would aver that he failed to perform the obligation, and therefore was in breach of his contract, and that the contract afforded you the remedy of removal. The court would agree, if you proved your facts, would pronounce the order, and oftentimes, as I understand it, would also, there would be an alternative conclusion for ejection, because if he didn't comply with the order of removal pronounced by the court, his title to be there was evacuated. He no longer was entitled to remain in the property, and he became amenable to ejection. If I may take my lords back to the 1970 Act, I was endeavouring to set Section 24 into its statutory context. A lot less interesting, I grant you, than this discussion, but I think I need to put the framework and the scaffolding in place before a judgment can effectively be made. So, if one looks at tab 2, between section 19 and 20, you have...
Would it be possible to have a copy of the provision which does require you to go to court to obtain possession of a property which is in the occupation of the defendant, apart from section 5? At some point.
Yes, my Lord,
Thank you.
I'll try to do that. So, section 19 and 20 is the calling up notice procedure. Section 21 to 23 is the notice of default procedure. And then we come to section 24, which is this present application. I propose to take Lord through.
Not too fast, please. Section 19 is calling up.
Yes.
And that's the standard condition 9.1a.
It is.
And it refers to debts. And are we to understand that as a thing that applies to money obligations?
Yes, my Lord.
And when it talks about serving a notice in section 19, subsection 1, calling up the security, do I understand your position to be that if you want to do that, you have to serve that on both of the proprietors, if that's the kind of security we've got here, where it's granted by two people?
Yeah, that's at 9.2, my Lord.
Yes.
You can see that. Subject to the following provisions of this section, a calling up notice shall be served on the person last in theft in the security subjects and appearing on the record as the proprietor.
Yes. So you look at the state of the register and you see there are two people who are joint owners of the house, and you have to serve the calling up notice on both.
That's
And is that meets the requirements of section 5?
It does, my Lord.
So it's all quite simple in
Very
the
simple.
section 9.1a thing.
Well, it's not, I mean, it's 19.1, as I understand it, debt. Isn't confined to monetary debts, because we find the definition in section 9.8.
Oh.
9 subsection 8c,
Do we?
Where?
Well,
where it includes, because you find it, you go
sorry,
back,
9. Section 9.
9 subsection 8c, because the definition section in section 30 tells us to go to 9.8c.
Oh, yes.
And that includes any obligation to pay an annuity or ad factum price
Oh,
standard.
I see.
Yes, my Lord.
Yes.
Yeah.
Right.
Yeah, I'm
I see.
grateful to my Lord. That is absolutely right.
Yes, thank you.
But those, however widely defined, those are all monetary obligations, are they not?
No, an obligation ad factum price standard need not be, my Lord.
Could you tell me,
Yes.
give me some idea what that could mean?
Do anything, just to do it.
Yeah, an obligation ad factum price standard to a Scots lawyer is an obligation to do something.
Or to repair.
For
For
example,
example.
that's a good example.
Very good example.
And you could grant a security of that obligation to do something.
Yeah.
So an obligation to maintain property or something.
That's another good example,
Absolutely.
my Lord. Yeah.
But it's a little odd because, and any obligation to pay an annuity or ad factum praestandum, that's any obligation ad factum praestandum, is it?
Yes.
Yes.
It isn't to pay ad factum
No, no.
praestandum.
No, my Lord.
Now, is that an innovation on the bond and disposition in security? Could one have a bond that actually contained, under the old system, contained an obligation ad factum praestandum, or is this something that is an innovation which was one of the advantages which the new system was supposed to introduce?
I'm not an expert in this one, but my understanding was that you could, under bond and disposition and security, that you could write the security contract as you please.
Yeah,
but I may check with Milano.
Probably could.
Bonds don't sound too good.
Milano Junior doesn't know, and if he doesn't know, I
think-
certainly don't know.
Bonds, I don't think were, I mean, bonds are usually, I've always thought of as monetary. but,
Yes, I mean, I thought this was something which the 1970 Act introduced. It was
It
one
may
of,
well be,
one of the advantages that the Law Commission must have seen in the new form of security, that it could actually enable people to get securities in in securities of obligations of maintenance or whatever else. But
My Lord, that may be right. I don't know.
With the utmost diffidence, I do wonder whether this isn't, because every standard security contains in Schedule 3 standard conditions, maintenance and repair, not to alter buildings, planning notices. Those surely are the sort of non-monetary obligations that were concerned with in this case, aren't they? And which are typically the obligations referred to in paragraph 9(1)(b) of the third schedule. Isn't that right?
I don't think so, my lord. I could stand to be corrected. I think the way condition 9, the standard conditions in Schedule 3 are, is that if I advance money to you, the bank has an interest to ensure that the collateral put up, the property, remains good for the money.
Of course, yes.
And therefore, standard conditions are inserted into the security so that the bank can require of you to maintain and repair. And if you fail to do so, then a notice of default.
Yes, that is just what I was trying to say. Is that not the typical situation covered by 9(1)(b)?
Yeah, well, I could see certainly the force and logic of that is that that would be an obligation ad factum praestandum.
Because it does say any other requirement arising out of the security, and it does seem to me quite odd if for a monetary obligation you can have an option to go either under 9(1)(a) or 9(1)(b), which seems to be what the bank is doing in this case.
But we still have this problem, don't we? You have two separate processes provided for in sections 19 and 20 to deal with 9(1)(a) type problems, and section 21 et sec to deal with 9(1)(b) type problems.
Yeah.
And it would be odd, wouldn't it, if the bank could choose whichever it found the more convenient.
I think that is just the way it is. Is that the bank does have the right to elect, because it is a fact that I just can't put my finger on the statute provision just now that it's the opening of section 24 without prejudice to the proceeding by way of notice of default in respect of a default within the meaning of 9(1)(b), a creditor may seek warrant. So it seems that the two can run side by side. You could issue a notice of default, but you can also, at a time of the bank's choosing, issue proceedings under section 24. So that assumes that the two run side by side. And my understanding certainly is that the bank has a choice as to whether to call up or proceed under section 24. My understanding, and it's not easy to grasp, is that the point of section 24 was speed. If the bank wanted to move quickly and didn't want to take the time that a notice of a calling up notice would involve, because there are periods of time.
So where is that? Where are these periods of time? In section 19?
It's in section 19, my lord. Subsection 10 refers to the period of notice.
Schedule 6 Form A gives you 2 months, and Schedule 6 Form B gives you 1 month.
Yes,
is that the point you're
That's
making?
the point I'm trying to get at, yeah. So section 24, its utility is that the creditor can move.
Well, it seems even odder if the bank can say, well, I ask for your money under 1 and give you 2 months, but I'll go under 1, which doesn't fit so well, but I'll give you 1 month. I mean, that's a very strange scheme, isn't it, for Parliament to enact?
Yeah.
There must have been some sort of report that preceded this piece of
There
legislation.
was, lady. Yeah.
Just to be told what it was would help.
We'll endeavour to clarify.
Mr.
That's the holiday
Summers,
report to which my Lord Roger made references.
what is
Yes, well, that means nothing to me, so.
No wonder. 91B, what do the words at the end of 91B mean? What is the requirement arising out of the security?
Well, come to this. There was a little debate in front of Sheriff Craik when this case first got into court as to whether that was apt to cover the facts of this case at all, because my argument rejected by Sheriff Craik was that it arose out of a different instrument, which was the bank's contract with the firm, and not out of the personal obligation. But that was rejected, and I think correctly, that in this case, the failure to comply is the failure to act on a demand made.
You say it's a failure here to fulfil the obligation, the husband's obligation under the bit at the beginning of the standard security.
Yeah.
And so you say that arises out of the security.
Yes.
But are you accepting that formula would apply to a failure to fulfil the obligations set out in standard conditions 1, 2, 3, 4 and 5 and so on?
Yes.
And if there's a failure in those ones, the only way you could go, it looks to me, would be under 91B.
Yeah, no, that's absolutely right. So 91A is just a very straightforward calling up notice, required to pay, and if you fail to pay, that's a default. 91B looks at all other failures that might exist. Now, classically, you've got all the standard conditions in 9 to repair, insure, and maintain, and so on. And that is a requirement arising out of the security. But in addition to that, you've got the requirement to pay under the bond, which is the one that applies in this case. The bank don't complain in this case that there's been a failure to maintain or repair. In fact, the irony is that the couples in this case lived happily in the house and paid their monthly instalments under the security quite happily, and I think one of the members even paid off their security, by the by. But the obligation here arising out of the security is the obligation that emerges from the personal bond and undertake to pay on demand.
If you have a case where suppose in this case the wife had only given security in respect of her share of the house, but wasn't a primary obligor, could you serve a calling up notice under Section 19 in those circumstances? You could you?
I think so, my lord.
You could.
Yeah.
It simply said, unless the money is paid, we will go in. It's not a demand to her to pay, but simply says, unless it is paid.
Exactly. But the point for which I contend is that it's very clear that notice must go to the proprietor. And that was the consistency across Section 5 and Section 19, is that the notice goes to the proprietor and the demand is made of that individual, so it would satisfy Section 5.
So what would the calling up notice say?
There's a form at the back.
Page 44, I think.
Page 44, isn't it, my lord? Thank you. It's the foot of page 44.
So that's not a demand of the recipient to pay, but simply a notice that unless the money is due under the primary obligation is paid, then
well, it is a demand, because the Lord will see. Take note that CD requires payment, and failing full payment.
Yeah.
So it's a classic example of what I would call a formal requisition under Section 5, is that it requires payment and is formal to the extent that it fills in the formalities of the demand, which is...
What is a calling up notice? What does calling up a standard security, what is that? What's calling up?
I think to call up just is another way of saying demanding payment. Another.
But you can't demand payment from the wife if she doesn't have to pay. If she's not granted, she's not obliged to pay. All she's done is to grant the security in Lord Clark's example. How can you call upon her to pay?
Perhaps we should look at Halliday to see what...
All it says is in Form A, it's calling up of the standard security, which makes sense, and says, take notice that if the money isn't paid, the subject to the security may be sold. Which, that makes sense, doesn't it?
Yeah.
I mean, I don't...
Maybe that's all it does.
It's a
It is
notice
to meet
saying,
this very case, that it's to support the security.
because
that
this
isn't.
debt is due,
Yeah.
if it's not paid,
Yeah.
we're going to enforce against
Yeah.
the property.
I don't know if this begins at all to address my Lord Rogers and my Lord Clark's point, but I think probably what is meant is that although you cannot put your finger on a contract or bond which requires it to pay, what you're saying is, look, if you don't pay, we're going to exercise our rights and securities. You've got an
If
opportunity.
it isn't paid,
That's
not
it.
if you don't pay,
That's
if
exactly.
it isn't paid.
That's it.
That's the point, and that's what it's saying, I
Yes.
think.
That's
Failing
isn't it?
full payment.
So she gets this thing.
Yeah.
She goes round to her husband and says, what are you playing at here? You realise what's going to happen to my home if
Yeah.
you don't do something about it.
Yes.
And what about that money you've got stashed away in the Channel Islands bank account? Let's get at that, because otherwise we're going to lose our home. Or she says, right, well, I'd better go and see if I can borrow it, because I've got a good job, or whatever, or I'll sell my jewellery.
Yeah.
That's
That's exactly what... That's why she's got to know.
Yeah, exactly. Yeah, I mean, I've steadfastly tried to stop looking at the equities of how all this case comes to be before this court. But the miserable feature of this case is that the wives didn't know, and they never knew till the action began. And by that stage, 25% interest had made the sum unmanageable. And that is.
Well, she knows now, and I suppose we'll have a new notice.
I beg your pardon?
Well, she knows now, and presumably one can have a new notice. Indeed, what I think is quite astonishing about this whole case, the litigation has been going on for about N years, and you'd have thought that the bank would have served a notice complying with all your requirements years ago.
Well, the thought has occurred to me that the cheapest and simplest way just to cut the Gordian knot was the day after this action was defended, is for something for the bank to do it, as I would say it, the right way, and serve a notice. But, I mean, if the day comes when they do serve a notice, I shall be standing ready with my plea of prescription. But
But why are you not submitting that in this class of case, you have to go under Section 19? As my Lord Walker pointed out a minute ago, it's very, very bizarre if you look at these two notices in Form A and Form B.
I could see the force, my lord, of that. This is
Section 19 does use the word shall, and it describes the circumstances in which this is mandatory in quite general terms, it seems to me.
And the note to Form A makes it clear that in the case of a non-monetary obligation for which the standard security is granted, you adapt Form A accordingly, so it can cover non-monetary as well as monetary.
Yeah.
So it looks as though it's capable of covering the entirety of whatever might be secured by standard security.
Is that contrary to what's been held by the division in a case which I haven't looked at? Yes. Is that right, or am I wrong?
contrary to
Lord McLean's case, is that right?
Millward, yes.
Well, I think it's quoted, isn't it, by in the
Yeah, I just saw it mentioned, but
judgment in this case.
We've got it here.
Yes, it's paragraph 39 in the judgment of the court below, and indeed there's a reference to Halliday as well in paragraph 19. They seem to suggest that you have a choice. You can either go under 91A or 91B.
So we have the case somewhere, do we?
Millward is in the authorities, my lord.
Your word?
Is this a supplementary one or something, is it?
No, it's not in tab 10.
Thank you.
Lord.
Tab 10.
So what do they say?
Well, the head note suggests they are saying there's a choice.
Yeah.
Yes,
Yeah,
that's
that
right.
is correct. Well,
Yeah, the question is how did they get there and what's it say?
Really through Professor Halliday, didn't they?
page 903 at letter H.
Yes. Well, before you get to H, there's a reference to between E and F that Professor Halliday suggests the remedies are not mutually exclusive. And Professor MacDonald seems to say the same thing.
But what's the point of providing two completely separate processes with different forms and different requirements?
Yeah. Well, in my innocence, my lady, I had thought that what section 24 was there for was just the need to get straight to court, where you didn't want to give time to sort the thing out, because either the situation was beyond remedy, or...
How can you, I mean, why would Parliament specify one thing with time limits in it, and then another give you an alternative which will allow you to skip the time limits? You know, how could that? What policy would justify that?
Well, I mean, Lord, I have struggled to understand how these parts interact. That was the only explanation that I was able to hit upon, is that it was in order to enable the creditor to adjust his remedy to the need of the situation.
But you usually expect them to have an extra criterion, like, you know, it's being immediately necessary or urgent.
That's a very good point, my lady, and there's nothing to that effect. And
There are a lot of weight is put on the use of the word may in section 19, and the suggestion is, well, that's optional. And 24 has word may as well, doesn't it?
yes.
So what does that do?
Well, it's the word may, I think is, yes, it's,
But that may is if
Yes.
the bank decides it wants to go for the summary procedure of ejectment. It could go for a more solemn procedure if it wanted to. That's the option there, isn't it?
yes, I agree. It's letter H on page 903 in Millward. The law is correctly stated.
19.1.
Yes, I mean, it means, isn't the may coming out of, is it Professor Halliday may?
Yes, that's what he's saying. The framework in sections 19 to 22 leads to the conclusion, because it says may, and that suggests he may alternatively take the other route, they say.
So in other words, it's construing Professor Halliday rather than the Act.
And may is emphasised at letter E
Yeah.
on the same page. Yes, we've supplied the emphasis.
Yeah.
But it says shall in section 19.
It does.
Yes.
Are we looking at the same print as the court? On page 903 in the left-hand column, they quote the section in different terms from the section we
Oh,
have.
sorry.
Don't they?
Divided.
Well, it's the author's may, isn't it?
Oh, it's the author's, but in
think
the
so.
section.
It's quoted at 901I correctly. He shall serve.
Yes. But I think the word may appears in Professor Halliday at letter E on page 903.
Yeah.
I mean, the example that's given right at the foot of the left-hand column in 903 makes perfect sense, that if the mortgaged property is in a very bad state of repair, well, then it may be in practice you choose to go under 9(1)B because it's quicker, but then you're going on the disrepair.
Yes. Yes.
And then he has another point at the top of page 903.
Was Millward the first time this matter had been examined by the Inner House?
It was, my lord, yes. And I do remember very clearly Lord Reid, when this case came out before the division, raising the very point that my lords are concerned with. And I think, Mr McElfry quite correctly pointed Lord Reid to Millward.
Yes.
And I have to confess that it had never occurred to me to even begin to think about trying to tease out the distinctions as to which route was appropriate. And I was content just to accept the authority of Millward, as I think I was bound to do before the extra division.
Of course, you can adapt Form A to include non-monetary obligations,
yes.
But there's no similar provision in Form B, the other way. So one view is if you want that the court decision of the Inner House is wrong, and that if you want full payment, or never mind by whom, then you must go under Section 19 and issue a whatever it's called notice.
Calling up notice.
Calling up notice.
Yeah.
I mean, there's obviously a suggestion that 19 only applies where you're actually wanting discharge of the debt, the whole debt. I mean, that seems to be that's what Millward is talking about as well, isn't that right? That's their suggestion. Otherwise, you can't use it if you're only asking for some partial.
Yes.
So what are they envisaging? They're envisaging there that you might be...
But in this case, the bank did want the whole debt.
Absolutely, yes.
Yeah.
doesn't help us.
Well, the whole debt of the partnership, but not, of course, the whole debt secured by the security.
That is true.
Of course, I don't know whether the ordinary mortgage loan had an acceleration provision which said that the whole thing becomes due if you default on anything that's secured. Maybe it did.
I'm not aware of that. It's one of the this is not me giving evidence, just my understanding of what the position was. As I understand it, at the time this came to court, I think one of the couples was either repaid all or nearly repaid all the loan they took to buy the house, and I think the other couple had put on a conservatory, and it was the conservatory that they were paying up at that time. But that's just by the by. I think possibly by today's date, I think the conservatory's been paid for as well. So really this case is about the partnership loan.
Yes. And it says, I mean, if you had several debts, distinct debts, it could hardly be that the Section 19 didn't apply if you wanted discharge of one of the debts.
It's got to be
It would
debt or
have
debts,
to,
hasn't it?
debt or debts.
Mm-hmm.
Which would be normal.
Yeah. So it really means a debt, thereby secured.
Where are we, Alan? Sorry.
In 19.
19.
Yes. Sorry, no, in Section 19.
Yes. I'm looking at the case of David Watson against Woolwich Equitable, which is in tab 16, where I find it necessary to go over quite a bit of the legislation, but I don't think I touched on this point.
No, it's a completely different
It's
case.
a new point.
Yeah.
It's worried that I'd sold the house.
My Lord, in the case that, in the tab there, my Lord will see that, my Lord the Chair, the only purpose, utility that case has in the context of this case, my Lord expressly acknowledges that the 1970 Act is designed to fit in with the underlying.
Yes, I think I said it was an amalgam of remedies found in the old statutes as well as the 1970 Act. But
that was the only point in the case.
Yes.
That such an issue didn't surface when it got to the House of Lords.
No.
But that, my Lord will see in his judgment, which is in that report, that he expressly finds that is the position. I will not seek to discourage my Lords and my Lady if that is the road along which they would propose to travel.
Well, I think you have to.
The expression intends to require discharge of the debt means debt or part of the debt, does it? Debt being any
or
means
one
any
of the debts
obligation
or
due.
any debt.
So if you were only wanting the discharge of the obligation to pay 1 week's interest, that would also be within section 19.
Well, I think that the division seemed to say no.
But if one looks at the definition section,
Oh, sorry, yeah.
Yes.
Yeah, where is that then?
well, debt means any obligation
Yes.
due.
Yeah. And it's 9.8, is it? Again?
Sorry, 9.8C.
That's
Yeah.
9.8C.
Including any such obligation arising from a transaction or part of a transaction.
Yeah.
So it doesn't look as if debt means the whole debt,
Not necessarily.
although it would include the whole debt.
For instance, let's assume that we're back on section 91B. One's got to construe section 24,
Yes.
one not, and to see to what extent one has to follow the section 5 route in order to give effect to what section 24 is talking about.
I hadn't prepared to develop an argument that said that Millward was wrong, so I hadn't had that in mind at all when I came here
No,
today.
fair enough, that's understood. But I mean, that's why I say that in case what we've been saying is not a ground on which we feel we can proceed, we've got to look at section 24 under
Yes.
the section 91B route which the bank has chosen.
Yes.
And the question is does that require the bank to follow the section 5 route, or is it self-contained when it talks about exercise of remedies?
Yeah, well, that is the key issue in play between the parties.
Yes.
As I say it is that section 24 is not intended to be a standalone, but that, as with other, if my Lord looks at the wording, just in the middle of section 24, he may apply to the court for want to exercise any of the remedies which he's entitled to exercise on a default. Now, I say that is a nod in the direction of the phraseology used elsewhere in the Act, which acknowledges that there are remedies arising, for example, under Section 5 of the 1894 Act. So what Section 24, we just step our way through it, is a creditor in a standard security where the debtor is in default within the meaning of that standard condition, and that standard condition is a reference back to 91B. And if we look at 91B,
Yeah.
which is at page 38, that says where there has been a failure to comply with any other requirement arising out of the security. And my understanding is that here, where there is an obligation to pay by virtue of the bond.
That's other as compared with what?
Other than the calling up notice in 918.
Other than failing to comply with a calling up notice.
So it's 918, the calling up notice. You failed to comply with a calling up notice. 91B is any other requirement arising out of the security. So if you look at the security, you put your finger on a failure to comply with a requirement emerging from that security. And that would, in my respectful submission, point to the personal obligation, because the debtors are not in default of any of the standard conditions. The only thing that they have defaulted on, allegedly, is the failure to pay on demand. So that is the requirement arising out of the security.
Yes. Now, does that arise out of the security, or does it arise out of the personal obligation?
Well, I had rather read the security to refer to the whole document, including the personal obligation. I had understood security just to be shorthand for the standard security, which part one of which is the personal obligation. And C doesn't arise in this case because there's no insolvency issue.
Supposing with a calling up notice, it would still land. You would still be using Section 5 of the 1894.
Yes, my lord. Yes.
It's the same thing.
On this side of the bar, the calling up notice is the paradigm. You know, that is an example as to just how it ought to look.
Yes. Because well, you only have to look at Section 19.1 to see that it's actually doing what Section 5 envisages.
Exactly. So, just in summary form, what we are saying is that a calling up notice is an example of a formal requisition, and the difference is that in Section 5 there's not a form at the rear of the Act to which you turn to see exactly how it ought to look like. But if you look at as we will do in a moment, the form at the rear of the Titles to Land Consolidation Act, you see something that, as near as makes no difference, is the same as the calling up notice under the 1970 Act, which is, you can see where the formality lies. I mean, formal is a difficult word to pin down, but I think one recognises when one looks at the calling up notice in the 1970 Act and the formal requisition under the 1868 Act, the formality would describe it exactly, because it in a very formal, precise and meticulous way steps its way through who the parties are and what they've got to do and so on.
But it doesn't give you, it doesn't allow the creditor to sidestep Section 5, because
Exactly.
Section 5 still trumps the standard conditions in the cases where that applies.
Exactly.
Is that made clear by Standard Condition 10.1?
It is not.
Because I mean, what one is looking at is Section 24 is talking about remedies, exercise of remedies, and that's the phraseology in 10.1. Without prejudice to exercising any other remedy, he may exercise such as the remedies specified in the following sub-paragraphs, but that is in accordance with the provisions of the Act and any other enactment.
And that's the key, my lord, any other enactment. So it's very clear that the Act is praying in aid the Section 5. It becomes, in my respect for submission, crystal clear when you look at standard condition 10 and you realise that it's entirely silent as to the method, the court actions that are the means of bringing home these remedies. It doesn't mention removing, it doesn't mention ejection, but it has got to be one of the two. You simply can't go straight to your remedy without your action, to either to remove or to eject. So that, in my respect for submission, just makes it absolutely clear that in this situation you go back to section 5 and find the route to follow.
What are the remedies referred to in the last 3 lines of section 24(1)?
Does my Lord mean that the phrase there applied to the court for want exercise any of the remedies?
Any of the remedies which he is entitled to exercise on a default within the meaning of standard condition 9(1)(a). Now, what are they?
Well, those remedies are the remedies that we've looked at in condition 10.
In condition 10, but they apply whenever the debtor is in default, don't they?
Yes.
So they aren't related to section 9(1)(a), to condition 9(1)(a), because those are rights of creditors in default. And section 9 says how the position simply identifies who are when you're in default, which contains A, B, and C.
Yeah.
So I wasn't quite sure what the last 3 lines of section 24(1) were directed to.
Well, maybe it refers back to section 20, subsection 1, which is what the creditor is told he can do if there's a default under standard condition 9(1)(a).
Yes.
Yes, perhaps that's right.
I think that's the way it would be.
That
And
is
so
how I understand it, Lord.
So that was a yes. So what does that mean? What does that include then?
So,
I see, maybe that's right. Yeah.
So, I mean, that says exercise such of his rights under the security as he may consider appropriate, and any such right shall be in addition and not in derogation from any other remedy arising from the contract or by any rule of law. So it's really, I mean, I'm just suggesting that it's a shorthand method of building in the formula which one sees in section 20, subsection 1.
Why is it needed? I mean, what's it doing? What's it adding? What is that? Is it adding? I'm sorry, I'm not quite clear. What does it add, actually? What does one get under 20? Which... You let the security subjects, right for warrant to let the subjects, be it 7 years, was tenant, blah, blah, blah.
Well, it perhaps reinforces the point that, but for it, sections 9(1)(a) and 9(1)(b) are entirely separate. And without it, it assumes that Millwood was wrong.
Yes.
Or is a pointer in that direction.
There's a right to show the right to sell the subjects.
But there is a degree of duplication, isn't there? Because 20 subsection 2, it produces just the same result as special condition 9 and 10(2) together.
Yes, that's right.
And if my learned is pointing to 23(2), subject to the provisions of section 21(4) of this Act, where a person fails to comply as aforesaid, the creditor subject to the next following subsection may proceed to exercise such of his rights on default under standard conditions 10, 2, 6 and 7 as he considers appropriate. So that narrows you down to the sell, the right to sell and the repair and the decree of foreclosure. I had to inform myself as to what a decree of foreclosure was. I'm not familiar. That is where you attempt to sell, but the debt, you either are unable to sell the property under the security, or you cannot realise an offer that is sufficient. So the decree of foreclosure gives the property to the creditor. It simply passes title to the creditor.
We have that in England too.
I'm delighted to hear it, my lady.
So I'm not sure what
I'm just explaining
that
23.2 also nods in the direction of the remedies that are available, but narrows them down. So that's under a notice of default. It narrows it down to the right to sell, the right to effect repairs, and the right to apply to a court for a decree of foreclosure.
2, 6 and 7. A person fails to comply.
But can we come back to section 24.1?
Yes,
Jan? This is what the bank is
Yeah.
wanting to do. And indeed, the initial writ was doing precisely this. It was applying to the court for a warrant to exercise remedies, including the remedy of ejection.
Yeah.
And the bank's argument, I think, is that just the plain wording of the section allows the bank to do that, and there's no reference to section 5. So the question again is, how does section 5 come into this, given the wording of section 24.1?
What I say is, one, if one looks at the Act as a whole, one sees that there's an explicit acknowledgement that the Act is designed to sit into and interact with, lock into the underlying provisions of the law. And if moreover one looks at Schedule 3, one finds that Section 5 is explicitly not removed. So one has to read Section 24 along with Section 5. It doesn't evacuate it.
But Section 24 is much wider, because it could apply to a factory let to a tenant where there was no question of personal occupation, couldn't it?
Exactly, yes. So you construe Section 24 so as to fit in with a clear and uncomplicated section that plainly applies to the facts of the present case.
Just wanting to see how you achieve that result through the wording of the statute, and can you point me to the provisions? Is it section 32, or is it section standard condition 10, or a combination of them, or what?
Well, the section that keeps alive is section 32, as my Lord acknowledges, which says that the provisions of any enactment relating to a bond and disposition or assignation in security. I just pause there. If one reads section 5, it uses the little phrase lands disposed in security, which is a reference to a bond and disposition in security. Lord, see that?
Where is that?
In section 5, the very opening line says lands disposed in security. Now, you would look at a standard security and say, well, that's not lands disposed in security, but what that refers to is the bond and disposition. And what section 32 does is that the provisions of any enactment relating to a bond and disposition or assignation in security shall apply to a standard security, except insofar as such provisions are inconsistent with the provisions of this part of this Act. But without prejudice to the generality of that exception, the enactments specified in Schedule 8 to this Act shall not so apply. So what that is doing is just acknowledging that the language of Section 5 is just a reflection of the forms of its day. But Section 32 is carrying over the benefit of Section 5 to the standard security. And if one cross-refers to Schedule 8, one sees explicitly that Section 5 is preserved.
But do you need to look at standard condition 10.1 as well? Because this is, after all, the initial writ is an attempt to exercise a remedy.
Yes, and I revert to my point, is that standard condition 10 The critical one is enter into possession. That's the first crave of this application, is to enter into possession. And the point is simply this, that you cannot enter into possession without either removing or ejecting. Possession is a consequence of a legal process.
How does section 21 fit into all this?
Very good question.
The notice of default, my lord.
Well, where the debtor is in a standard security is in default within the meaning of standard condition 9(1)(b. Now, this is such a case, as is suggested.
Yes.
And the default is remediable, which
Yes.
presumably this is,
Yes.
because it could be remedied by payment.
Yes.
Then the creditor seems to have the discretion
Yes.
to serve a notice of default.
Yes.
Now, what's the rationale behind that?
Well,
Unless in a section 9(1)(a) case, you have to serve a notice of you have to serve a coming up notice, or whatever it's called.
yeah, well, leaving that to one side.
But what's the rationale of giving the bank a discretion, if it does, whether to serve a notice of default?
Well, again, I can only offer my understanding, and my understanding is that some defaults are minor and easily remediable, and it would be a draconian remedy to go under section 24. And for example, where there's a want of insurance or a minor want of repair, the bank might not wish to go in with the tanks, but rather serve a notice of default. So it's driven by the facts of the case, as I understand it.
But all within the discretion of the bank, and
Yes.
no protection for the
No.
debtor.
Well,
Not
that
that
seems
I'm-
very bizarre.
Well,
Yeah.
the opening words of section 24 say that's without prejudice to proceeding by way of a notice
Yes.
of default. So it looks as though there is an option to that extent.
Yep. As I understand, the two could run alongside one another. You know.
But I suggested to you that actually supports the proposition that if it's a section 9(1), condition 9(1)(a) case, you've got to serve one of these other notices, which gives protection to the debtor. I quite see that if this is about remedying other types of defect, like repairs and so on, there's a whole plethora of possibilities. And to require a notice of default in every case might be...
Well,
but the purpose of this statute, at least, is at least in part to protect the debtor.
I could certainly see the logic of
And it has quite detailed provisions about notice of default and what the defendant can do. But it does require a notice to be given to the proprietor. And even in this case, where the proprietor is also a debtor, they'd have to have given notice to the... Well, if they were going to operate Section 21, a notice would have to have been given to the wives. And to construe the whole act as if there was no such obligation, to my mind, would be very odd. In this class of cases. Quite apart from Section 5.
Yes, Lord.
Well, where do we go from here, Mr. Summers? Are we...
Well, I think where I was in the order of my submission, I was trying to sketch in where Section 24 sat alongside the calling up notice, alongside the notice of default.
Yes.
And I've explained how Section 24 is a right that arises where there's a default other than one that's a failure to comply with the calling up notice. So you look to try and find a default arising out of the security. Seems to be here that the default is a failure to pay on demand in connection with the personal obligation in the preamble. And I've tried to also explain that even though that is so, that doesn't oust or remove the terms of Section 5, because one reads Section 5 along with the 1970 Act, and I have submitted that it fits the facts of this case. You have people who are in personal occupation of the security subjects. The wives are proprietors, and on the face of it, they're entitled, therefore, to a formal requisition, which, it is accepted, has not taken place in this case. Now, my Lord, what I would like now to do is to try to show to my Lords, how the innovation that Section 5 effected on the underlying law. And that requires me to take, my Lords, to tab 19 and Lord President Dunedin. A case called Ingalls Trustees against McPherson. Just read the head note there. The trustee under the anti-nuptial marriage contract of Mr and Mrs Ingalls raised an action in the Sheriff Court at Inverness against Mrs McPherson, widow of the late Donald McPherson, Messbank, Inverness. The suers craved the court to grant warrant to eject the defender from the dwelling house known as Hanover House, Messbank, Inverness. So, warrant to eject. Now, the Lord President was Dunedin. The part that matters is in the second column on page 177, and about halfway down there is a sentence that begins, under the law prior to the Heritable Securities Act. Do my Lords have that?
Yes.
Under the law prior to the Heritable Securities Act of 1894, the remedies of the holder of a bond in disposition in security, apart from sale, with which we are not dealing, were these. He could enter into possession by decree of mails and duties. He could, if he found the proprietor in personal occupation, turn the proprietor out, but not by summary process. Now, my Lord will recollect this is a warrant for summary ejection. And then he says, I think that was settled by the case of Blair against Galloway. My Lords, I will endeavour to show that perhaps Blair against Galloway didn't quite settle it, but there is another equally authoritative decision that undoubtedly did settle it. And then he goes on to say, and he could at any time turn out a mere squatter.
What does turn out mean? Does that mean physically go there with heavies so. And...
Yeah. The sheriff officers are the usual heavies that are relied upon in these. They quite relish these episodes, I believe, but that is the way to turn out. The creditor could also, having entered into possession by an action of mails and duties, either live in the house himself, or he could let it for as much money as he could get from anybody who chose to go into the house and who was content with a very precarious tenure, because the tenure at any moment could have been put to an end by the proprietor paying up the debt, in which case, of course, he would resume possession. Well, now, the difference that the Act of 1894 made was this. By Section 5, it gave a summary remedy where there was not a summary remedy before. And the very terms in which the summary remedy is expressed show quite clearly that it recognises the right of a heritable creditor to put out a mere squatter, because the terms are, and then he repeats Section 5. Then after the close quotes at the top of page 170, provided always that default had been made in payment of the interest and so on, that was the first thing that the Act did, and we don't need to concern ourselves with Section 6.
So before this, could the lender turn out the borrower, or the occupant rather, not by a summary process, but by a long process, or whatever the opposite of a summary process is?
Yeah. Well, this will become crystal clear as I go through the cases.
So what's the answer?
The answer is that it's an action of removing. You could turn them out by an action of removing, declarative removing.
So was Section 5 only about summary process?
It was about two things. First, if you got a proprietor with title, he could be treated as a squatter, and because he was a squatter,
he could. But was there another method of the lender proceeding by the old long process, unaffected by Section 5?
Yes, I think this morning when I was...
Does that still exist?
It still exists, yes.
So we ought to look at that.
I'm going to take my Lord...
because that would be an alternative method for the bank.
That is what my submission comes to, is that it's not that Section 5 is the only...
So it's quite important to see what that other remedy is, the long ref method.
Yeah. I'll take my lord through the.
I mean, does it have a similar proviso?
Well, it's not a statutory remedy. It's a common law.
Which remedy is it?
The remedy of declarator and removing.
Declarator and removing.
Yeah.
So the remedy of declaratory removing still exists?
It does. Well, it's a common law remedy, and there's no reason to think it's not there.
It doesn't, the proviso which you find in section 5 isn't there, presumably because under the ordinary procedure, you look at the facts and everything else, and you look at the state of the titles and so on.
I mean, at the risk of just retreading ground that I was covering when I was discussing the remedy with my Lord Roger this morning, what the common law gives you is if you're a proprietor with a title, you're not allowed to be turned out as a squatter because you have a title, you have a right to be there. But the way you get rid of a person from land who is a proprietor with title to be there is that you raise an action of declarative removing. The court examines the contract. If there's been a default, a declarator is issued that he has no title to be there, and that evacuates his title to be there. Right. And then hard on the heels of that, as I explained to my Lord Roger this morning, one is entitled then to eject. And that remedy is still available.
That remedy would have been available to the bank here, would it?
Yes. I don't suppose they'd have relished it very much. But
why not?
Well, it's slow. So well. The great benefit that Section 5 was intended to confer was to give a summary process where it would otherwise not have existed.
All I can say, I seem to remember nightmares of things that the ejection is available only in the sheriff court or something like that. Is that right?
Well, I didn't catch the start.
Ejection only in the sheriff court or something, not in the court of session, something like that.
But my lord, the cases.
I seem to remember a nightmare about that.
Jurisdiction.
Yes.
As a take my lord through.
No, I don't want to go into that.
No,
nightmare.
We will run from those sections of the case law where they turn themselves inside out.
Yes.
Trying to work out. We've got a lot of the cases that came up to the Court of Session seeking remedy objection. The first ground upon which their lordship said we're not entertaining this is it's come up from a sheriff court that didn't have the jurisdiction in the first place to grant that remedy. But that's a case called Wiley, and I'm proposing to come to that just in a moment.
But actions of removing are used, aren't they, relatively frequently in cases of leases, where there's an argument as to whether the tenant has a right to remain or not, and that has to be conducted through the ordinary process because there may be questions about proof that there's a breach of some provision in the lease and that it gives rise to a right to recover possession.
That is where the action still has life in its legs to this day. It's still used where a tenant disputes the right of the landlord or to turn him out or to turn him out of the lease, and an action of removing is the vehicle which that is ventilated.
Yes. Well, we don't need to look further at Ingalls.
No, we don't, Lord.
Yes.
To turn from Lord President Dunedin, I would now like to turn to tab 26, which is Craigie, who also discusses this. Tab 26. Craigie, a respected writer on conveyancing, and he deals with this issue at page 949 of his textbook. And just towards the foot of the page, in the last paragraph, there's a sentence that begins, where a debtor was in the natural possession. Does my lord say that? Where a debtor was in the natural possession of the security subjects, the creditor could, before 1894, without a decree of mails and duties, oust him from possession by an action of declarator and removing, but not by either a summary process or by an action of mails and duties. So that's as clear a statement of the position as one.
And that's back to Blair and Galloway.
Yes, I'm going to take my lord through this. His footnoted authority is just.
So an action for mails and duties wouldn't do, would it? Why wouldn't it do?
Mails and duties is an action for the rents.
Oh, I see.
If you've got a tenant in possession and you want to gather the rents, an action of mails and duties, a quaint title, I grant you, is the remedy.
So just suing for the rent is not enough to get a possession order?
If you wanted to take from the debtor the right to collect the rents, then you would raise an action of mails and duties, and you could step into his shoes and gather the rents. So my lords will see that Craigie is acknowledged as the natural possession, that just means personal occupation, before 1894, without a decree of mails and duties, you could oust him from possession by an action of declarative and removing, but he's explicit, but not by summary process. Now, if we now look at Professor Gordon's...
So does it say what you can do as an alternative to Section 5 here?
It does. It says an action of declarative of removing.
But does it explain that? And what sort of notices do you have to give?
I don't think... the action is the notice, is it? There's no statutory forms. You just raise your action.
You just start an action?
Yes.
And in your process you say what the basis of it is?
Yeah, that's what it comes to, yeah.
So you don't have to give any... You don't have to give any notice of the kind we've been discussing here.
No.
You just start proceedings against the person in possession.
That's right.
And assert that the debt's unpaid.
That's right.
And the other party has an opportunity to contest that.
That's right.
Well, why don't people do that? It seems quite straightforward to me. No banks do that. You don't have to trouble with any of these other things. You don't have trouble with Section 5. It doesn't matter whether they're a deemed trespasser or not. You just simply say we want a declaration or a declarator. You then plead the case.
As I say,
and then we'd find out whether there's any defence to the...
Yes, well, that's the point, isn't it?
On the
It
underlying
takes time.
merits.
Because it takes time.
I think it's a speed issue. The reason why Section 5 was...
But why should it take any time if the only possible defence is we've paid or it's been paid?
Well, we will have paid by the time we get to court.
Yes, but I mean, none of those points seem to be raised here. And in many of these cases...
It's difficult to understand this without looking at, which I hope we don't have to do, the different procedures and the timetables that are laid out for proceeding summarily as compared with what you have to do in an ordinary action.
I dare say it would take less than the time that's taken in this case.
I sincerely hope so.
This case has been to the division on a separate point.
Yes.
With the wives, whether they could have had a sniff and back out again. And I think probably we're getting to the point now at the very end.
Well, is there time to look at one with further authority before?
Yes, I think there is. The Lord, authority, I think, does aptly describe Professor Gordon.
Yes.
His contribution is found at tab 30.
Yes.
And at page 394, he, at paragraph 1423,
Yep.
what he says there is, ejection is the appropriate remedy against a party who has taken possession by violence and against whom it is no longer possible or against whom it is not prudent to use equal violence to regain possession. But then if my lords drop down 4 or 5 lines just after footnote 49, but it seems that a party with a prima facie title may bring an action of ejection against a squatter alleging no title. So he's making the point that it is perhaps a commonplace, which is that ejection is the remedy that is deployed where somebody does not assert title. Now, removing, by contrast, is dealt with in the following page at letter D.
Yeah.
And what the professor states there is that an action of removing is the appropriate remedy for recovery of possession from a party who claims to have a title to possess valid against the pursuer, or who has had a title to possess and refuses to give up possession. So that's the essential difference between the two remedies. That may be a convenient point at which to, for the present.
Thank you very much indeed. Well,
and which of these is the declarator?
It's the removing one, D. So you get you would raise an action of declarator and removing. The declarator would just simply be exposure contractual right.
Thank you, yes.
And the removing would be the remedy following.
well, we look forward to seeing you at 2 o'clock.